Hey everybody, this is Uncle Grumpy. Welcome to Grumpy Tonight here at Max's Garage in downtown Muskogee. Tonight we've been joined by Ron Durbin. Ron, I want to thank you for coming on tonight.
Thanks for having me.
You have been instrumental in fighting the towns in the overregulation that they've been reaching for, this ridiculous draconian style laws they've been going for. I was hoping you would come on tonight and possibly break down some of what they've been trying to do and where you see how that doesn't fit into 788.
Sure. I'm first of all happy to be here. Thanks, Grumpy, for having me. Happy to share any information I can with people so that they understand kind of what battles we're fighting. One of the things that I really want to get out there is that there was a huge battle to get 788 passed on June 26th, but the battle continues every single day. And so one of the things that's important for people to remember is that they still have to show up at their local government meetings to make sure that these cities aren't passing regulations that are over-restricting the industry.
Now, I know you've been a leader in doing that. About how many cities so far do you think you've been involved in?
Grumpy, I think I've lost count at this point, more than 20 at least, probably more than 40.
So what do you think is so far the most outlandish, the most ridiculous thing they've tried so far as regulations?
Well, I think honestly the one I saw today from Wowoka is probably the one that to me screams the most as to what's causing this, and it's this this irrational fear that makes no sense to you and I or most normal people. And what it is they're comparing medical cannabis to alcohol. And so, like for the city of Wowoka, their ordinance, when they copied and pasted from various other ordinances, they did a poor job. And actually, part of their thing related to dispensaries talks about package stores. They didn't even bother to change the language. And what that does is it reassures me that we're correct and that they're treating this like it's alcohol and not medical cannabis and a product that can help people with their medical needs.
So is this just their attempt to keep it out of their town?
Yeah, I mean, what we see a lot of cities doing, for some reason, cities have this misconception that they can't touch dispensaries or they can't touch them as much. And so what I see in a lot of cities is I see them really restricting dispensaries and then outright banning growing and processing in their cities. And so, yeah, I think it comes from that.
Okay. Well, let's take this back to the beginning. After we passed 788, I don't even remember which town it was that started this, but I remember the first meeting I ran into you in was the meeting in Broken Arrow. And I don't even remember. Can you remind me what that exactly was about at that time? There's been so many.
Yeah, Broken Arrow, which I happen to live in the city of Broken Arrow, was meeting about some ordinances related to medical marijuana. They were trying to put some zoning overlays on medical marijuana dispensaries that tied into their alcohol overlays. So they were trying to seriously restrict where dispensaries could go, and they weren't treating them like pharmacies. And so, you and I were both at that meeting, and we all spoke, and we warned them and I warned them very clearly that, hey, look, we've been looking for a test case. You're in this is my city. I'm going to make you a test case. They ignored me, so we filed that Cloudy Mornings LLC versus the City of Broken Arrow case in Tulsa County. The Judge Pickrell, granted us an emergency injunction, which turned into a final injunction. Which the City of Broken Arrow has appealed to the Oklahoma Supreme Court. That case is actually sitting before the Oklahoma Supreme Court waiting for a final record on appeal to go up so that way they can hear arguments if they want to and make a decision.
Do you see obviously that's going to be a key case in the state of Oklahoma. It will be the first one addressing this issue to make it to our Supreme Court. Do you see a time frame as to when that could come through?
Unfortunately, when you're dealing with the Oklahoma Supreme Court or any appellate court, they kind of work on their own time frame. My hope is once I see the record on appeal certified by the Tulsa County Court Clerk, what we're going to do is we're going to ask for an expedited review. And essentially what that is we're going to say, okay, court, you've got the record you need, you've got all the pleadings and documents you need certified. Hear this case quicker because we need some kind of finality to this issue. One of the things that is frustrating is going from city to city over and over and over again, doing the same battle with this, with a different board, with a different city attorney over the same issues. And it would be nice if we can get a final decision.
Well, now, yeah, it would be, but isn't this something that 788 brings upon itself with the lack of details and specifics in some areas, like this area?
You know, 788 is certainly lacking in detail with regards to a lot of issues. I'll agree with you there. But on these particular issues, as lawyers, we rely on what's called the common law or the case law to sort of guide us in what the law is. And in this instance, I don't think 788 needed to speak about those issues. 788 spoke by not speaking. It did not expressly grant cities the authority to require these ridiculous permit fees and require these inspections and require these them to be in certain areas, you know, and adding all these additional restrictions related to parks and playgrounds. So I think 788, by not giving cities authority, speaks volumes.
But now, what I'm seeing that they're doing is every single one of those places where 788 doesn't directly speak, they're saying, well, it doesn't speak to that, so we can. So what do you say to that? I mean, because that's what I'm hearing from the cities, the councilmen.
Sure, they're getting bad legal advice. That's what I'd say to that. That they have incompetent city attorneys that have not researched this issue. And that's one of the things, and when I say incompetent, or ignorant might be a better word, because they've just not looked at this issue. And when we've dealt with cities that are receptive to anything to do with marijuana, and they look at the case law and the things that we provide to them, what we're seeing is they realize that, yes, they've overstepped their bounds, and they're going back and they're repealing these things. So a lot of this is just, and it's fortunate, a lot of this we can solve through education. And then we deal with some cities that just dig their heels in the ground. They're going to spend as much money as the city has to defend a lawsuit that they're ultimately going to probably lose.
Yeah, I'm noticing that some of these cities seem to be entrenched, and they would just as soon burn the house down as let this cannabis industry exist.
Absolutely.
So, I know there was a lot of press come out of, was it Grove recently that you were involved with? I know also, as I like to call him, our fearless floor leader, John Eccles, spoke at that meeting.
He did. Yeah.
Can you fill us in on what happened there and what that was all about to begin with?
Yeah, so the city of Grove passed a bunch of ordinances that restricted where dispensaries could locate. I had a client, you know, and one of the things I want to point out is I do the work on sort of fighting the cities pro bono, so the client didn't get a bill for this. But they passed these ordinances. My client wasn't going to be able to open. And I looked through the ordinances, and they were the same over-restrictive thing that we had with Broken Arrow. So I spoke with the city attorney at length about the issues. I thought we had a deal that they were going to go back and repeal their ordinances and put in some ordinances that actually complied with 788. They reneged at the last second on their deal, and so we stopped playing nice and started playing the way that we needed to get the results we ultimately got.
So that didn't even have to go to court, did it?
No. Once I threatened to sue the counselors in their individual capacities and fight them trying to get their legal bills paid for by the city, for whatever reason they decided that discretion was the better part of valor there, and they backed down. So.
Can you tell me anything about the case that's going on out in Weatherford? I've heard a lot about that case.
Yeah, so we filed for an injunction in the city of Weatherford. The judge was on his way out. It was, in fact, we'd heard that he wasn't going to hear our case, and we show up that morning and he's there. Hadn't been there in 2 months, but he showed up for our case. He denied our injunction, and you know, the thing about the Weatherford law is actually what the Weatherford law provides is that all businesses must comply with all local, state, county, and federal law in order to operate. And what we thought our point was very easy in that case. You can't possibly comply with federal law because it's still federally illegal. And for whatever reason, we can get into the politics of it, that judge didn't agree with us. So the injunction was not granted, but that doesn't mean our case is dead. We're still moving forward with the case. And ultimately, I think what's going to happen is the Broken Arrow decision is going to solve our problems there. And get us the result we need. It's the same case, essentially. And fortunately, what's funny is that one of the clients who was trying to open in Weatherford on Main Street, he's now right across the street from the county courthouse that made that decision.
Yeah.
And he's opened his dispensary there. So,
yeah, I did a patient drive there just
about
a week or so ago.
You know, that's Custer County, and he's right across the street from the Custer County courthouse. And you know, what's funny is they welcomed him with open arms, and they've had no issues. Yeah. So it just goes to show that the fears are irrational, and they're based on a lack of understanding. That's why ignorance is probably the better way to describe some of these fears.
I think this is what we're running into right here.
Yep.
It's just reefer madness, and unfortunately, here in Oklahoma, I think it stems from that same era, from the same, these people were raised by people who watched that, or they watched that themselves.
Well, I think that first meeting that we went to with Broken Arrow, where they spent, on another proposal, they spent probably an hour and a half talking about how late people were going to dance. I think that footloose mentality, as I like to call it, I think that speaks volumes for where some of this is coming from.
Yeah, you would see a movie like that nowadays, and I, anyway, would think that's insane, that any town would be like that. But then you get involved in things like this, and you see that people really think that way. People really are that closed-minded on these kinds of issues.
Well, they are, and unfortunately, it is small-town Oklahoma where people can't afford to fight it. So, it's expensive to fight a governmental authority. And so, we've got cities like Wewoka, we've got cities like Ada, we've got Wagner County that passed all these weird zoning ordinances to ban growing from agricultural land. It's one of those things that's expensive to fight, and so a lot of times they pass these ordinances and nobody ever challenges them. And so they're in this instance, they're first getting the taste of what it feels like when there's somebody challenging them.
So what city are you taking on right now?
So we just resolved Collinsville.
Tell us what happened in Collinsville. Let everybody know first.
All right, so Collinsville, a dispensary that I did not represent up until this point, the World of Weed, they received a cease and desist letter from the city of Collinsville instructing them not to open their business. And it didn't explain why. Normally when a city, for code purposes, tells you don't do something, they say these are the codes.
Yeah, you would think they would have to give you justification for shutting your business down or preventing you from opening in the first place.
Right. And my clients had been over there multiple times. They'd applied for every permit they thought they needed. They were told that, hey, the city of Collinsville hasn't even passed any marijuana ordinances. Come to find out, the city of Collinsville had passed marijuana ordinances. Apparently, maybe they hadn't been typed up yet. And there wasn't.
So they passed them, but they weren't typed up yet?
They weren't.
I hate to stop you there, but I need that explained a little bit.
Well, we actually talked to a city. I don't remember if it was Collinsville or if it was another city. Maybe it was Wewoka, actually, that we talked to. And they passed ordinances, but they had to make some changes and do a final draft of them before they could give us a copy of them. That's happened a lot.
Is that the way of saying, well, we're not done figuring out how, but you can't do anything?
Right. Kind of. It's weird. I'll give you that. But it's oral amendments made during the hearing when, then the clerk who's supposed to do that doesn't do it for a couple of weeks, so it just sits on the back burner, and they never actually codify the ordinances and sign them.
So what ended up happening in Collinsville?
So in Collinsville, I reached out to their city attorney and explained to him the issues, and he knew who I was and what I was there trying to accomplish. And miraculously, they had an application form for their dispensary permit done the next day. I received that by email. We don't agree with their permit fees. We don't agree with their permit application fees. But I went ahead and had the clients go fill that out, submit it to the city. Miraculously, they managed to process this application in less than 4 hours. And that included an inspection from the fire marshal.
Really?
Yes.
Well, that's some quick service.
That was some quick service.
Can I ask how much that quick service cost? The permit fees?
Yeah, for Collinsville, it was $100. And again, the law is very poorly drafted. It says permit / application fee is $100. Then down further, it says the permit fee is $1,000. So the way they interpreted it was, it's a $100 application fee and a $1,000 permit fee. Now, we're not done with that. I don't think the cities can charge any permit fee. So we're going to deal with that as we move forward. But in this particular instance, my clients felt, and I agree, getting open is the primary focus for them, getting the patients served in Collinsville. So that's what they've done. We're going to be dealing with the permit fees moving forward.
So will they be open soon?
They're actually opened. What's funny is as soon as they got inspected and he signed off on it, which was last night, they went ahead and opened for a little bit and served a couple of patients. And they've been open all day today and no problems whatsoever.
Good. Okay, well, I've got a whole bunch more stuff I want to talk to you about, but we're going to take a break, and we'll be back in a few minutes with Ron.